Okay, take the roll, please.
Commissioner Adaro.
Here.
Commissioner Hatch.
Here.
Commissioner Hayward.
Here.
Chair Remke.
Here. Okay, good morning. I would like to start with just a couple remarks. First of all, as many of you have heard, Commissioner Kasher has formally stepped down from his position this month after being kind enough to hold over for about 5 or 6 months, and we really appreciate that. He has a new job opportunity. He's been appointed to the City Attorney of Pinole, which creates a conflict to serve in both roles, so he had to step down. I would just take a moment to thank him for his years of service, because I'm sure he's listening, even though he's not here, and his expertise in government law and his vast experience in this area was a huge benefit to the commission, and I really appreciate his service, and he will be missed. I would just add that we have notified the Attorney General's office of this issue, and we are hopeful that they will move on an appointee in the near future. We shall see. The other thing I would like to point out is just that we do have our new General Counsel, Jack Woodside, sitting here. Jack brings over 20 years of legal experience to this position. He has worked for the Commission since 2012. Before that, he was with the AG's office, and so we're excited to have him, and welcome, Jack. Okay, as for public comment, I would just like to start by saying, to state for the record that yesterday the Commission received a request for a Commission opinion from the Senate Democratic Caucus regarding whether contribution limits apply to the amount a state candidate can contribute to a recall committee controlled by another state candidate. Procedurally, pursuant to the Bagley-Keene Open Meeting Act and our regulations, that request for an opinion will be properly noticed and placed on the agenda for the next Commission meeting in August. In the meantime, the request and all related materials are public documents, which are available upon request from the Commission Assistant, and of course, all that material will be properly posted for the next meeting. Any other public comment?
Good morning, Madam Chair, members of the Commission. Richard Rios on behalf of the Senate Democratic Caucus. Just on that last point with respect to the opinion request, I had actually submitted a request on June 12th requesting that the Commission consider the issue of whether state candidates are subject to limits when they contribute to recall committees controlled by other state candidates. We had hoped to get that issue on the Commission's agenda today so that the matter could be substantively dealt with today, either by the Commission declaring a policy that the staff's interpretation on this point was incorrect, or providing guidance for some type of guidance for a different legal determination. We believe that the staff's interpretation is clearly wrong on this issue. And we submitted yesterday a legislative council opinion which supports our analysis that that conclusion is incorrect. Instead of agendizing the matter for today's meeting, the Commission instead treated my request as a request for an opinion, which it was not. And it was deliberately not an opinion request because we were concerned about the length of time that it would take for an opinion process to play out. We don't think that the opinion process is likely to conclude until the fall at some time in October, especially given the fact that opinions are subject to review or request for reconsideration. So we believe that the policy, what we believe is needed is a policy decision by the Commission that the staff's interpretation is incorrect, and we believe that the opinion process is not the most efficient way to make that determination. So yesterday I submitted another request with an alternative proposal to the opinion request, which was for the Commission to agendize a regulation at its next Commission meeting in August. We believe that draft regulation or consideration of a regulation will much more efficiently deal with the issue that needs to be resolved, which essentially is going to require the commission to establish a different policy or direct the staff to have a different legal interpretation. So that was the request that we made yesterday, and that I also wanted to explain the request we made on June 12th.
Okay, but again, there is nothing that's been properly noticed for this agenda to discuss substantively. And I would just like to clarify the record, Mr. Rios. First of all, the only avenue to request and receive a legal determination is an opinion. And that is why the executive director properly tried to direct you in that road. Second of all, as you're fully aware, that issue could have been on this agenda had you timely requested a request for an opinion or request to review the executive director's opinion. I mean, I feel like the fact that you missed that deadline is not to be put on us as us not moving quickly enough.
Madam Chair, our law firm has been involved in the past in discussions or direction by the commission to clarify policy positions or to direct the staff.
But this isn't a policy position. As you said in your letter, you were requesting a legal determination. I don't know how that could be viewed as anything else than a request for an opinion. Again, there's nothing on this particular agenda that we can get into deciding anything, and this will be fully discussed in August. And as we told you in the response, that we will move as quickly as possible to discuss this and get a resolution.
Madam Chair, the purpose of my appearing here today is not to question what the staff did or say what they did was legally wrong, but what we are requesting is that the commission proceed with a regulation at its commission hearing on August, at the August commission hearing. We believe that that's the most expedient way to bring resolution to this issue in a way that to bring speedy resolution to the issue.
So again, what you're asking for is that action be taken by this commission today to agree to holding a regulation in August, which again requires proper notice. That's an action item for us. So again, we can put along with, it's in your request for an opinion that you filed yesterday, a request for opinion and a request to review the regulation. Both those items will be discussed in August once they're properly noticed.
So are you saying that the commission will consider a staff holding a hearing or consider a draft regulation at the August hearing?
We don't have a draft regulation. Nothing's been properly noticed, sent to the Office of Administrative Law. I think you're putting also the cart before the horse, so to speak, by the fact that your opinion letter, without getting into too much request, is a disputed issue. How are we going to draft a regulation to resolve a disputed issue before we've resolved the disputed issue? Again, I feel like we're getting close to violating the open meeting law right now on an issue that has not been properly noticed.
Okay, well, let me just reiterate, if I may, Madam Chair. I will conclude by saying that we are requesting that the commission deal with this issue at its August hearing.
Which we've told you we will. It will be noticed for the August hearing.
Well, what's noticed at the August hearing is consideration of whether the commission will actually issue an opinion, because the opinion request was treated, because my June 12th request was treated as an opinion by the executive director, and then the opinion request was denied. And so
as is the regulation procedure was followed.
And so what's on the commission agenda in August is for the commission to consider whether it will actually issue an opinion.
I'm assuming there will be a rather extensive substantive discussion about the need for an opinion or not, based on the discussion of the law and the state of the law at this time.
But the problem with that is that the actual process for either issuing an opinion will not commence until at the earliest the September meeting, and we feel that time frame could be more efficiently dealt with if a regulation was noticed at the August commission meeting.
I understand your position. Anything else?
Thank you, Madam Chair.
I have a question. Hold, could you stay, please?
Yes.
Thank you.
And again, I'm going to just remind the commissioners of our obligation under Bagley-Keene Open Meeting Act and getting too far into the substantive nature of the item and our position or thoughts on the item leading us down a different path when this has not been properly noticed. But okay, Commissioner Odero.
So thank you for that reminder, Chair Remke. A question about procedure. So if we treat the request as the request for a commission opinion and the request was denied, under the regulations, a commissioner or an interested person can request a review of that denial, correct? Okay, so, and a majority of the commission can then approve the granting of an opinion report, which means that the denial is rescinded, right?
That's correct.
Okay, so maybe we keep this as a request for a commission opinion. We decide as a commission whether we are going to rescind that denial, and we can move forward a lot more quickly, right? Because your issue is you want this resolved quickly because you have the recall election and you want your clients want to be able to contribute to that, correct?
That's correct.
So if we rescind the denial and we proceed with the issuing of the commission opinion, don't we as the commission also have the ability to waive all the time limitations on that process and create our own calendar, correct?
Well, you can't waive the other parts of the law, like Bagley-Keene, which would require notice of the matter and that in 10 days in advance of the meeting. So I think it is correct in this, our own commission regulation on the opinion request,
Okay.
that those deadlines are movable. But on some of the other parts of the law that are overlapping here, including Open Meeting and Administrative Procedures Act, are not
Okay,
waivable.
so I'm not suggesting that we have a substantive discussion here. I'm just saying maybe what we do is we set this for a hearing. I assume you'll waive notice, right? And we can do whatever notice we need for that particular
But are you
hearing.
suggesting that based on the fact that we would be rescinding the denial at this event? That's what requires the notice that has not been properly noticed. And
I thought that the request for the denial automatically is notice.
his request for opinion has been denied.
Right.
He requests a review of that decision. The review of that decision is what requires proper notice and an opportunity for other people to weigh in at the next meeting, which is in August, where we'll be having this debate whether or not the denial of the request was proper, whether we as a commission would like to have a commission opinion issued, at which point, if we agree yes, then it kicks in all those timelines which you are talking about, which we can shorten, waive, but again, it would be hard to be acting on whether the legal determination when the process is a memo from the staff that gets publicly noticed for 2 weeks, then response from any interested party 5 days before the hearing. I mean, I would just stress again that they're asking for a legal determination, and this is a significant issue, obviously, that has been pointed out. And so the procedure is in August, we will discuss whether or not that should be granted.
So let me just understand as the kind of quasi-new kid on the block, at least as to this procedure. So we as a commission can't make a determination today, you're saying, to rescind the denial? When we have to notice, how is that properly noticed?
When it's put on the agenda in August as a request to rescind denial, it will be an item with all the material, including all of Mr. Rio's letters and the executive director's response. And I'm assuming a memo from the legal division as to our procedural options, and then we will vote on it. If we were to take action today, we are taking action on something that has not been properly noticed. And I don't want to hit Mr. Rios too hard, but again, this is a situation we are in because the request was untimely. Although it could have been timely made and with time to post it, to discuss it for this commission meeting. So again, we are subject to the laws of the Open Meeting Act, and that is what we are doing.
Chair Remke,
Commissioner Hatch.
I have a couple of questions on process. I thought what was going to be agendized for the following meeting in August was a review of the denial. And now I hear a different term, rescind. Did you mean those terms interchangeably?
Yes.
Okay. So what I think I hear, and I'm not sure it's clear, is that this path we take in August will decide whether or not to issue an opinion, not what the opinion says, but whether or not we will go forward. So then in September, we'll probably discuss some form of whether we have, try to feel each other out to see whether we are, we have one opinion.
Well, again,
And,
I think
and
in
then
August it
maybe
will be a fair.
October we'll have one to actually
No, I would-
act on.
I would think because of the sense of timing that we're hearing, when the discussion occurs in August, if we decide that we should issue an opinion on this, obviously there will be substantive discussion because the issue is substantive, whether or not the status of the commission position on this issue is correct or not, or whether we need to revisit it in an opinion will be rather substantive. Based on that discussion, when we bring it back in September, we could direct legal division to have a draft opinion ready for us that we can then publicly discuss. And if we agree, we can approve it in September and then it's effective upon approval.
Okay. Is it procedurally not allowable to ask the chief counsel to prepare two versions, a yes and a no? In terms, I'm talking now about an opinion. One says yes and the other says no. That can be acted upon at the August meeting after we take the initial vote to decide whether or not we will do an opinion. So we could actually do both steps in the same hearing. Is there anything in terms of notice requirements under Bagley-Keene that we would be?
I don't understand. The August meeting is a yes or no on whether or not we will be issuing an opinion.
That's different than we're going to actually decide which direction we're going to go.
Right. And it would be, no, we would not be able to do both at the same time because once we decide we're going to issue an opinion, there is a process again with a hearing and a memo that does have to be released and an opportunity for parties to respond. I mean, I guess I'm getting confused by condensing this so fast or why we're rushing or this urgency need on a position that's been in place for 15 years and to recall elections.
Well, similar to justice delayed is justice denied. Late money is not very helpful in an election. And so the longer we take, the more chance that the person who's affected is going to be hobbled by people of extreme resources who will have no limits on how much they can spend to try and recall the legislator in question. So I'm just looking, if we've got 2 months of notice this we can do. So I don't see why we couldn't have two agenda items, one to make the decision whether or not to override the denial, and a second agenda item to adopt one of two alternative decisions that would be pre-drafted and noticed and all the rest of that stuff. I just don't understand why it would have to do a second round of notices.
Well, again, I will say
I'd be happy to
Right. No, at the very least, again, I stand by, I'm really uncomfortable, and I think it is a violation of the Open Meetings Act for us now to be deciding things to alter the process of our regulations and
I'm
let me just
just
finish, please.
asking a
I
question
know, that's why I'm just trying
of
to tell you.
procedure, not merits.
Yeah, no, that's my response is on procedure. I do think we are going to the route of taking action at this meeting, even including process, which is making a decision about how we proceed without it being noticed. Again, there is no item on the agenda, and to take action.
I'm not asking that anyone take any action at this meeting on it. I'm just trying to get some procedural questions answered so then I can subsequently exercise my right as a commissioner or a member of the public to ask that these things be agendized for August. That's all. I don't have the answers. That's why I'm trying to ask the questions.
Okay, so right now, I think the safest answer to your question is that the procedures and the regulations are and will be followed.
So
That doesn't answer my question. I want to know whether or not there's any impediment in the law that would prevent us from agendizing 2 items on the same hearing date.
That would require us at this meeting to make a decision to change the procedures that the regulations set out for this request.
No, we don't have to make any decisions today.
Okay, I understand your position.
Okay, it's not a position, it's a question, and I didn't get answered. So then that leads me back to my question of Mr. Rios. You had suggested pursuing a regulation. Did you mean that in parallel with this, or did you mean instead of this?
In parallel, I think that what's the act of reviewing the executive director's denial of the opinion request is ministerial. That will be on the August agenda, no matter what happens, whether or not you decide to also discuss a regulation or opine on a regulation. The commission does have the ability to notice a regulation at its August meeting, which would largely resolve the same issues as are being presented in the opinion request. If the commission decided to adopt a regulation which clarified the issue, then there would be no need for a commission opinion.
I guess a question to the chair. Chair Remke, where you have an existing advice letter that says A, and then we adopt a regulation that says B, do we have to rescind the advice letter in order for the regulation to be followed, or is it override previous advice letters?
If we were to adopt a regulation that is different than an advice letter, the regulation would control.
It would override the advice letters.
Correct.
Okay, thank you.
So the issue here is almost at time is of the essence, right?
That's correct.
So we keep talking about the August commission meeting. And the reason we're only talking about August is because for our convenience, we're not having a July meeting. So why not have a July meeting and move this along?
There is a process in the regulations. It's Regulation 18310, which allows 2 commissioners to request in writing a special meeting of the commission. So that would be a possibility if.
And then we would look to the Bagley-Keene Open Meeting Act again as to what qualifies as a special meeting. And I would just like to clarify that I canceled the July meeting as the regulation authorizes me to do so for reasonable cause. As I believe everybody knows, the reasonable cause is the week of what would have been the July meeting. The entire agency is moving to a new location, which is going to have the entire staff, including all of IT, all of our equipment for recording and the like, shut down and moved. So it is logistically impossible, or was, for us to hold a July meeting, and that is why it was previously canceled again. And I understand that the commissioners are sympathetic to Mr. Rios' request. Mr. Rios has been aware of this issue, has contacted the commission since at least mid-May, was directly contacting our former general counsel, told of the position that it still was effective from the legal division's point of view, waited 2 weeks, wrote an email, got a response saying, yes, that's still the position, waited 2 weeks, wrote a letter, got a denial, waited 2 weeks, and filed a request yesterday. So, I mean, I think it needs to be put in context of this emergency nature of this.
Okay, just a few things. We may not be able to have the commission meeting on that particular week, but we can certainly have it the following week. And I understand the concerns of, and I know what it's like to move a huge office. I understand. But I also think that we're here to serve the public. And I think that we need to try to do our best to give responses to the public in a manner that makes sense with respect to the timing of whatever the issue is. I think that it's just become, it sounds like it's too easy to just say, no, you didn't follow procedures, when there are ways around this. And so I think we should have more of a discussion about why we can't move this along a little bit faster, along with what Commissioner Hatch has said, justice delayed is justice denied. I agree with that.
One further question on the July meeting. Could the chair not call a regular July meeting, but change the date to an earlier date than the move, so that you?
We still would, okay.
I know that would make it, then you might run into notice issues, but
Right,
like, for
correct.
instance, we're actually kind of behind on this month. We should have, according to our usual schedule, have had this meeting last week. So could we not hold the July meeting a week earlier than it otherwise would be, but I know puts it a little short, but I think, I'm not sure on the number of days that you have to notice the meeting.
10 days.
10 days. Okay, we're in good shape there. Is there, on this review question, does that require a specified number of days before that can be considered a public notice?
Just the regular 10 days.
Okay, so we could theoretically have our regular July meeting a little earlier to facilitate not having to have it happen in the middle of the move. Theoretically, anyway. Maybe other issues I don't know about that should be considered.
Right. There would be other issues, including my unavailability. And again, I'm having difficulty seeing this as an emergency or special meeting situation, as I tried to go through the timing several times on this issue being brought to our attention. Our attempts, and I'll just stress our attempts to help the requester understand the process and get the process before us as quickly as possible. At some point, I feel like it's not just on us. And so I am not inclined to set a regular meeting in the first week or two of July. And that I do not think will give staff sufficient time to prepare a memo for us to consider and have a thorough discussion on this issue, which again would require the 10 days notice. So I don't see how that's possible.
How much time does staff need when staff has been taking the position for, I guess, since May, that this is the rule? It's been briefed. I imagine it was briefed a while back. We've taken the position, we immediately apparently took the position, no.
That position, as you read in the letter, was based on the 15-year standing of the commission when the original regulation was adopted in 2002, with the second recall regulation adopted in 2003, and the time that the commission, not the advice letter, the commission adopted those regulations. They also adopted the fact sheet, which set forth the issue that's now before us.
Which was in 2003, right?
Right, during a recall.
Right. And so,
And none of us were on the commission at that time.
Oh, I understand.
excuse me.
I'm not implying that the issue is not subject to reconsideration. I am just strongly trying to comply with the open meeting laws and provide sufficient time for the issues to be briefed and the public to weigh in on this issue. So again, as much as Mr. Rios and his clients would like this to be heard immediately, I'm saying that they are not the only interested party in this issue. And I do not see the benefit of rushing it at this point when it was not rushed on their side.
I have one final question, Mr. Chairman. Ms. Chairman,
Yes, Commissioner Hatch.
thank you. Should we punish this senator for Mr. Rios's actions?
I'm not punishing anyone. Again, Commissioner Hatch, this is the longstanding position of the commission. This issue is not new to anyone. I'm just saying, as far as issues brought, when you look at special meetings and emergency meetings and the reasons to rush matters through, it is for circumstances unforeseen. Nothing here is unforeseen. If in fact the senators, and they have both outside counsel by Mr. Rios, apparently they now have in-house counsel by Ledge Counsel with a change in position, perhaps the fastest course is to change the law to clarify their position. That would take immediate effect and action if they so chose. So I think no one's being punished at this point.
well, I would disagree that the fastest course is to change the law. I think the fastest course clearly is for us to take a position on it, and whether it be through a regulation or issuing a commission opinion, I think that that's way faster. With respect to, we seem to be going back and forth on, we have a long-standing position, but it would take us forever to brief it. Makes absolutely no sense to me. There isn't that much law on the issue. I looked at it. It didn't take me that long. So, and I'm new to this law. So I know that council is going to be able to brief it a lot faster than I ever would. So I don't agree that it's impossible to have a fair hearing on this and have it fully briefed if we have an earlier meeting. With respect to an emergency
Again,
meeting.
I'm just going to say the 10 days
right now
notice.
I have the microphone.
Excuse me.
I have the floor. So with respect to an emergency meeting, the parameters of unforeseen circumstances, I don't know. I don't know what the parameters are for an emergency meeting, so perhaps you can provide us some guidance on that.
I think it's a special meeting you're
Okay.
referring to, not the emergency, but
Well, I'm using
yeah.
Chair Remke's term. Okay, so perhaps you can tell us what the requirements are for both.
The special meetings really just when unforeseen circumstances require that the commission not have to comply with the normal timelines involved, something unforeseen.
So can you give us an
personnel
example of
action
something that has happened that the commission has set a,
They've been used for personnel actions where it's in the interest of the commission to act quickly in litigation scenarios where, perhaps we have to know there's some form of notice of appeal that has to be filed, or
is it kind
something
of
that's going to prejudice a commission that was completely unforeseen and couldn't get on the normal 10-day notice or
Is
the
that
normal
language
agenda.
is that language in the regulation, or is this?
It's open meeting laws. It's Bagley-Keene.
So could you tell us what it says?
I just have a summary here, but it says that Special meetings are part of the Bagley-Keene Act to provide relief to agencies that, due to the occurrence of unforeseen events, had a need to meet on short notice and were hamstrung by the Act's 10-day notice requirement. The special meeting requires notice at least 48 hours before the meeting to the members of the body and all the public. The circumstances for which a body can call a special meeting are quite limited. Examples include pending litigation, legislation, licensing matters, and certain personnel actions. And I think just to clarify a little bit on Bagley-Keene, when we're talking about emergency or special meetings, it's really shortening that 10-day normal
Right.
notice requirement.
Okay.
So, a
So
regular meeting just requires the 10
just
days.
the 10 days. So
There's no impediment
a July meeting.
to do a July meeting on whatever day we pick, as long as you meet the 10-day notice.
Correct. But I would also just underscore what the chair has said. I mean, we are literally moving 80 people in our entire operation. And just to give an example, because you were saying, Commissioner Hatch, like the week before the move, that's July 13th. That requires notice to be given then on July 3rd, which is 2 days from now, two business days from now.
Could be done.
And I think, to your point, Commissioner Darrow, although we could brief something, we obviously want to do as much diligence and put together as best staff product as possible for the commission. And I think, to be fair, at this point, it's Tuesday or Thursday at 10:30 and whatever time it is. And, to ask.
With a holiday coming around the
Well,
corner.
yeah, and we do. I mean, but also, that we would have to have all of that put together tomorrow. We are in process of moving our items out of this office as we speak. And so, that is a lot of a burden for us at this point. But those are just factors those are external things that are going on.
When is the move complete?
We're moving everything on July 21st. And
So-
we will be that's a Friday. We're intending to be operational on July 24th, that Monday. But
So-
we'll have staff working that whole weekend to make sure we can be operational.
So we might be able to hold that hearing after the move in July?
Possibly. If we did that, I personally would recommend renting space somewhere else, because that assumes everything is operational, which is not, as anyone who's moved their own house knows, we might not have
Our
internet. We don't know.
offices, Sure.
I'm sure CalPERS would let us use their hearing room.
Yes, there are spaces
What-
we can find if that's the desire of the commission.
What other alternatives do we have to move this along faster, Council? If August, if in the judgment of the commission, August just seems like a little bit too late, what are alternatives? We can call a special meeting, which we've kind of talked about. We can have a meeting that after July 24th. What else can be done? We're counting on you to
Yeah, well,
to
you know,
inform us.
We're
all the
constrained by all
possibles.
these bodies of law, and just to push things for the sake of pushing them, we can't do it. We have to comply
Well-
with all these timelines, and that's why they provide emergency meeting rules and special meeting rules. And if what we're dealing with fits into one of those exceptions, then that would be the alternative.
Can we withdraw the advice letter?
I think the issue is it's not just that advice letter. I mean, I think, as was said earlier, the commission adopted, and again, it was a previous commission, adopted the recall fact sheet in 2003, which specifically addressed this question.
I see.
And also the regulation, which obviously there's a difference of opinion about how expansive that language is, but that regulation was also adopted by the commission in 2002, I believe. So the advice letter that then comes out in 2008 is based on those earlier precedents that were adopted by the commission.
And the procedure is to review it and decide whether or not to, which is a two-step. At least.
Right. I think it's this was said earlier. I think in theory, if the commission adopts an opinion, it has the effect of rescinding that advice letter. But that advice letter, it just, there's no real provision for actually just rescinding that.
I see. So
That makes
sort of
sense.
Overridden.
Yes. So that would just be, this is sort of a new process by just which this commission would then be making a legal determination based on the statutes.
So What is the way to move this along as quickly as possible once we get this on a noticed meeting, whenever that would be? So we notice, what do we need to notice at the meeting to move this fast? Is it just because it seems that if all we notice the meeting for is that a consideration of whether to rescind the denial, right?
Correct.
Then we have to notice another meeting for, or do we notice a hearing that can take place 2 weeks later? What's the quickest way to make this happen?
I think that's a good alternative, Commissioner Odero. We can discuss this issue at our scheduled August 17th meeting, and during that time, it will definitely be, if the commission decides to issue an opinion, we do have a hearing process, and as you said earlier, those we could lay out at the August meeting when the hearing would be and what the timelines are.
Okay, so that again assumes August, and I'm not there yet. But my question is, what do we have to notice? Can we notice, as Commissioner Hatch was saying, can we notice 2 things at once? Do we just have to notice the opinion, which then triggers yet another notice? What's the fastest way? What's the fastest route? Other than, I understand Mr. Rios, a regulation, I get that. But that aside.
If I could just comment on the regulation question really quickly, it is actually not going to be that fast because the Administrative Procedures Act requires that a regulation be noticed 45 days in advance. So it's not just our 10-day notice. We also have to have that on
Fair
file at Office of Administrative Law. I just wanted to
No,
note
that I understand. That's why I'm not going down that
we're
road.
already kind of running. If we wanted to have that on August, we're basically running up against 45 days to today or in the next couple days. So I'm not convinced the regulation really could make an August agenda based on the Administrative Procedures Act.
Fair enough. I'm trying to move this along faster. I'm sensing that there is pushback on moving this at all. That aside, I would like to know what is the absolute fastest way. What do we need to do to get this resolved sooner rather than later, according to all the rules that you're aware of?
I think we've provided it. Under the normal circumstances for issuing an opinion, it's usually a 2-meeting process, and that's not including the decision that reviews the executive director's decision.
Just 3.
So
Yeah.
so normally this would be a 3-step process from here.
And we really need to
We've-
have a July meeting then.
Yeah, I agree.
No, he's saying he already suggested a 2-step process to get around the
Yeah,
3-step
so
process.
we've said, okay, well, in September, assuming that we do reject the executive director's decision, we'll go ahead
Or
and
July.
create a 1-step process from there to get the opinion adopted.
And Commissioner Hatch, we had discussed what you brought up earlier, depending on how the August discussion goes, presenting staff drafting up, both options if it seems that that's something the commission would like to see in September, so that the commission could adopt whichever opinion you deem to be your desire.
Yeah, that was.
But
the
they would
suggestion I
both be
made,
presented
we could
so
do
that-
2 separate agenda items, act on one and then act on the other, and have the 2 alternatives for us to debate and discuss in public.
And as the chair said, obviously we would take direction at the August meeting. So, depending on how that discussion goes, then staff would have a better understanding of what the commission is inclined to do. And obviously we'll take that direction and present, something that's in accordance with that at the September meeting.
When is the election?
It's unclear at this point. The recall petitions are still being circulated. It could happen as early as the fall.
When?
I believe
September,
that
October,
it's
November.
pretty widely discussed that the push is for June.
Well, there may be a push. I can't speak
And in
knowledge.
fact,
of
the
that
law
because
was changed to address that. Wasn't that not correct? I mean, let's just put the facts out there.
We don't know exactly when the recall election will be because the petitions are still circulating. So
Is
proponents.
it not the position of your clients that it should be held in June?
We would like that result, but that doesn't mean that that result has been determined.
Is it your position that time is still of the essence?
Yes.
I move that we have a July meeting.
A second.
I just want to clarify for the record what, are you calling a special meeting under the Bagley-Keene Open Meeting Act?
No, general meeting.
No, I'm calling.
No, well, we have to have a proper procedure. I'm sorry.
Okay, so why don't you either help me out, because you know the rules. Why don't we try to make this work? How can we get a July meeting? You've canceled the meeting that was regularly scheduled because of the move. Fair enough. All we need is 10 days to notice a meeting, correct?
Yes, that's correct.
Okay, so if we schedule a meeting for some time after the move, so that we can keep this process moving, what would you call that meeting? You tell me.
I think that would just be a regular meeting of the commission.
Okay,
If it's set by me at a regular scheduled time, correct. If it's being called a special meeting, it goes under both our regulations and the Bagley-Keene Open Meeting Act.
Well,
I'd
excuse
just
me,
like to
Madam
hear
Chair, on that point,
Oh, God,
is
I'm
this
gonna-
then a special meeting? Because it's not on the regular date. It's
No,
not
actually-
on the third
actually it was set.
Thursday.
I would like to hear from Commissioner Hayward as to a July meeting if we did it the last week in July and your availability.
I would make myself available.
Okay, so trying to figure out if it's, so I will set a July 27th meeting. The only issue to be heard will be this issue, the request to review the denial of the commission opinion.
Madam Chair, may I ask?
Like,
a
I'm
que-
gonna, let me finish, please. So I'm gonna ask that this probably will cost the commission money, in fact, that we have to find a different location because I think it's unlikely that we'll be up and operating. So we'll have to look into that, and then we'll notice the time and location of the 27th meeting at least 10 days prior. So I would just encourage people to double check on the time and location when that is noticed.
So we'll notice it on July 17th.
Yes. No,
Well, the notice.
the notice will be
Yeah.
on the 17th.
and is it at 10 a.m.?
Yes,
It's
we
gonna-
will.
we'll
Since we have to
strive.
look for space,
Okay.
we'll. Our goal as staff will be to try to find a convenient space on July 27th at 10. Obviously, we'll communicate with you guys as to that location. We'll do our best to make it 10 o'clock, but I can't guarantee that until we can look for space.
Sure.
Just a point of clarification, Madam Chair. So the process then, or the intent then would be to adopt a final commission opinion at the August meeting. And the procedural rules will allow a final adoption of the opinion at the August meeting. Is that correct?
I would not say that's the intent. I'd say that's clearly a possibility based on the commission's decision on the 27th and direction that we give to staff.
Great. Appreciate the time, Madam Chair and Commissioners. Thank you very much.
Thank you.
Okay, so are there any other public comments for items not on the agenda today? All right, hearing none, we'll go to the first item, which is approval of the May 2017 commission hearing meetings. Are there any changes or comments from the commissioners? Okay, is there a motion?
Second.
it.
Second?
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Rumkey.
Yes.
This motion passes.
Okay, we'll move to the enforcement consent calendar items 3 through 30. Good morning, Ms. West.
Good morning. I'd like to make a couple notations before we begin. We'll be pulling item number 9 after the amendments were filed. It needs a couple tweaks before it gets represented to you. And then on item number 7, after it was brought to my attention that there was an error in how the vote was portrayed, I reached out to the respondents and talked to them about making a slight change to correct the error. So on item number 7, page 4, line 4, the sentence that reads, it starts on page 3, the measure did not pass, receiving only 43.23% of the vote. We will be deleting that second clause so that the sentence will then read, the measure did not pass. And the respondents have agreed to that change.
Okay, would the commissioners like to take any items off the consent to be voted on separately?
Yes, I'd like to take number 4.
Any other items?
Yes, Madam Chair, I would like to pull number 3.
Commissioner Hatch, anything from you?
I didn't have any items to pull off. I did have a question to raise.
Okay,
when
so
we get there.
let me just clarify if that's the only items 3 and 4 will be pulled and 9's off the calendar. Commissioner Hatch, questions regarding the remaining items on the consent?
Yes, thank you, Chair Remke. In reading these stipulated judgments over the last 3 months, I find it a little bit difficult to evaluate from the information there whether a particular item is out of inadvertence or on purpose, or whether it was there's 6 criteria that are named in every one of these, but it seldom does it tell you in the proposed decision which of those apply in this case. And I'd be satisfied with just a little check the boxes that it applies to number 2, 5, and 7. I don't care. I just would like to get a sense of, where this falls.
I'm sorry. Are you referring to a particular item just so I can follow along?
Oh, it's in every one of them.
Can you give an example?
You have to pull up the actual stipulated judgment.
I could give
Okay,
an
here's
example
one
if you'd
here. This is our water now. It just happened to be the one I opened it up to. So summary of the law includes the criteria, as I recall. Yeah. Let's see if I can give you a line number.
I believe it's page 5, line 25.
Oh, that's the counts. Oh yeah, I picked a bad one. I think the one I recall was that first drew my attention was item 1. Oh, it's not even there.
Would you like to let me give you an example?
Yes, please.
Sure. On item 3, on page 4 at the top, has the paragraph I believe you're referring to.
Which tab? No, is that
Item 3.
tab 3? Oh,
Mhm.
wait, I was way in the wrong part. Okay.
Page 4.
Oh, yes, there it is. The top paragraph on that page, you'll see that it enumerates the factors. That's the correct term that is used here. And so there's like I think, 6 factors that are supposed to be considered. But as you get down into the facts and the comparables, there's no reference to which, if any, of those 6 factors are applicable to this particular case. And so I would find it helpful, even if you just simply said factors 2 and 4 and 6 are the ones that are applicable in this case. And then you don't have to have a paragraph on each one or anything like that. That wouldn't, I just want to get a sense of the gravity of these things. So, if it's inadvertence, that's one thing. If it's like a repeat offense that seems to be a pattern of behavior, that's much more serious in my mind. I'd like to get that sense because there's not a lot here to evaluate, and we are deciding yes or no on these. So it would be helpful to me. I don't know how others feel here.
I think that would be helpful as well.
Agreed.
Okay, that's definitely a change that we could do. We interweave it in our tale, but we will definitely outline it a little
Yeah,
better.
I understand it would take a while before they actually show up in.
That's true. Yeah, it takes a while in the pipeline to get them all out and then approved and back, and
That would be great. That's fine.
all the horse trading. Thank you.
Thank you, Chair Remke.
Any other questions or comments for the remaining items on consent? Okay. Any public
I'm sorry, I just have general questions about the 24 through 30, just very general questions about those. So the annual statement ones are denoted as a violation of Government Code 87203. But I see that there's one, number 27 is an annual statement, but that's denoted as a violation of Government Code 87300. Is there a reason for these differences?
That's a good question. Well, since there's 2 types of filers under the Act, the 87200 filers, which you guys are, or the 87300 filers, which are the ones that file pursuant to their code. So the charge is different on whether or not you charge for their code violation or under the statute itself.
Understood. Thank you.
Welcome.
Okay, any public comment on the remaining items on consent? All right, seeing none, is there a motion?
Move to approve the consent minus, I think it was 3 and 4?
And 9, yes.
And 9. Yes, that was removed.
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, item 3.
Yes, Madam Chair. My issues that I want to discuss regarding item 3 are relevant to count 2, which is the over the limit gift. And it provoked, my question was provoked actually by the notation on page 5 that the respondent maintains he did not realize that his pacesetter award was an over the limit gift. And I thought, why might he not think that? So I guess my first question is, how did we get the valuation at $1,600? Do you remember?
Yes, actually, it's funny. The reason you don't know you had an over the limit gift is because you didn't report it.
Sure.
So if you had reported it, you'd realize you had an over the limit gift. Actually, we got the invoice from the trophy shop that produced it for the organization, and that had the cost billed to the organization.
Okay. Because what I was concerned about is, you might anticipate, but I'll explain to the rest of the room and the people watching at home, is that engraved trophies are not gifts if their value is $250 or less. And so it was curious to me how that's a very elaborate trophy, I suppose. I even went to find a couple of pictures of it online to know that it was one of those engraved trophies that people get. Now, I don't want to open a can of worms, but other public officers who are Californians have gotten pacesetter awards in previous years. And I'm wondering if they have the same lack of appreciation that he had, thinking if this is an engraved trophy, it's not a gift, the same way a fancy dinner is a gift and all these other shoo-shoo things are gifts. And I just wanted to test your reaction on whether or not this is something that is legitimately a matter of surprise to someone.
It's funny that you mentioned that because I actually printed out from their website who also received these awards. And it's generally organizations as opposed to individuals. But anytime we have a case like this where it seems a little unusual, we first look at the other people that also had the same award and check their SEIs just to check. And then also we use these as opportunities for education. So anytime there's something that's a little bit different or off the beaten track, then we communicate with the public education unit in order to say, hey, could you reach out to this type of person in this jurisdiction and make sure that they're following the rules.
And that they're asking the award giver for an invoice, I suppose. I mean, that seems to be the one way he would know how much the award might be valued at.
Well,
Okay.
generally these higher up officials that are getting these gifts are filing their SEIs timely and reporting and have the awareness.
Okay.
Any other questions or comments on item 3? Well, actually, I do. I just want to highlight that here it says approximately 40 sources totaling 21,000, and we don't have a breakdown. Is that because he did ultimately file his SEI with the breakdown?
That's correct. When you're negotiating on months in advance, you don't have the exact numbers because you're getting them to file the amendments. So he has since filed his amendment. We checked it. He's filed an amendment to his amendment, and so we're satisfied with it. We're still doing one issue, but it was basically a grand total unreported closer to 29,000, 55 unreported items from 45 sources, and 30 of those were for travel for speeches and panels. So the majority of them, 86% of the total were for speeches.
Okay.
And those are his numbers, right?
Right. Well, we also, and the investigation. So we
Right.
don't actually tell them what we have.
Okay.
Okay, any public comment on item 3? Seeing none, is there a motion?
I'll move approval.
Second?
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, item 4. Was that you, Commissioner O'Darrow?
Yes, it was. Thank you, Chair Remke. I just have a couple of questions. So this is a case about a lobbyist giving a gift over the limit to an elected official, Senator Calderon and his wife, and a bunch of people went out to dinner, I guess. And the penalty that was imposed was $3,000. And that was based on a comparator that you provided of Mayor Fuentes. But that comparison seemed not on all fours to me. That seemed like the opposite fact pattern. It was a penalty imposed on the public official for receiving the gift. And so I'm wondering why it is that that became the comparator rather than the case of Kevin Sloat, which was actually right on point. It was a lobbyist who was assessed a penalty for violating the same section as at issue here, and that penalty was significantly higher.
Actually, I'm very aware of the Kevin Sloat case, and it was considered in the negotiations in this case as one of the cases that we had as a prior. Kevin Sloat was the same fine. It was $3,000 as well.
I thought it was $4,500.
And for less of a gift, $50.50 gift of a meal. And the big difference between the cases was that the Sloat case had no reporting on either side, whereas the Fuentes case seemed more similar because it had reporting where there was no intent to conceal, so to speak, as with the Sloat case was more of a reading the newspapers was more of a intent to not show any activity. And so by using the Sloat comparison, it seemed to make it more nefarious as opposed to using the Fuentes comparator, which is more, they reported 100, it should have been 200, they shouldn't have been doing it at all. And, but there was you didn't see an intent to conceal.
Okay. So that makes sense. It would be helpful if, again, maybe we're just now adding to what you have to do, Ted, but it would be helpful to have that, because I found myself having to go look for the comparators. And I mean, it was right there, right? So, and you actually considered it. So, and your logic makes absolute sense. So I think it would have been helpful to, in the future, if you could put that kind of information in the report, that would be great. But I do have one quick question, and just now just for fun, how did we come up with this dinner being valued at $100 per person when there were 7 people there? I did the math and it was 150, just for fun.
Well, some public officials, when you approach them about gifts, never drink the alcohol at the dinner. And so the evaluation is different for each individual, as opposed to being, there's nothing in the act that says it has to be divided equally.
Yeah, no, fair enough. So the spouse didn't drink either. Okay.
They didn't take me, let's just say.
Or me.
I have a couple of questions as well.
Okay, Commissioner Hatch?
Thank you. As I recall looking at the STIP, the person who was represented by Mercury at this was actually not a registered lobbyist, correct?
Correct.
Okay. So it kind of caught me off guard because I didn't, I'm one of the Mossbacks from back in Prop 9 when there were no such thing as a firm, and each lobbyist had a $10, limitation. And now it's apparently a whole firm of 100 lobbyists would be dividing up a $10 cap. Is that not correct if I'm interpreting what the commission has said on
The
this?
lobbyists still have the $10. It's also transfers to the lobbying firm.
Right, but if
So even though
lobbyist
he's
A,
not a lobbyist.
spends $5 on somebody and lobbyist B spends $5 on somebody, lobbyist C has to be real careful that he's not going to put him over?
No, I don't believe that's how the caps work, but I don't know, Jack, if you want to.
I thought I got that from the detailed STIP, that was the commission's position, that the firm itself was limited to $10 in total.
Right, from the firm.
Is that like a separate person from each of the lobbyists?
Correct.
Okay, I
Sorry, it
misconstrued.
wasn't me.
I have nothing to
Clear.
say.
That's good.
I was about to say that.
All right, so each lobbyist can have their own $10. In addition to that, the firm can have their $10.
Coffee
So-
donut. Yes.
Yeah, so yeah, pretty much. So in this case, they hosted a dinner. Is that the firm hosted the dinner or somebody else hosted it?
The non-lobbyist, Fabian Nunez, took them out to dinner, who works for Mercury, who then turned it in as an
Oh, so this
activity
wasn't a
expense.
banquet?
No.
Where people didn't show and that's why the value went up?
No.
Okay, so this was actually just in a restaurant.
Yes.
Okay, thank you.
Any public comment on item 4? Seeing none, is there a motion?
Oh, one more thing on item 4, I think there's a typo that you should probably correct. It is on page 3, line 18. I think we have one too many zeros.
Well, that's our dream limit. So,
I get it. Okay,
thank
with
you.
that correction, I move approval of item 4.
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you.
Thank you. Okay, the final item are just the executive staff reports. Any questions or comments from the commissioners regarding the report?
Yes.
Commissioner Hatch?
I had a question on the legislative report. I guess I should wait until this is presented.
Well, there's really going to be no presentation other than questions, and we can call up the appropriate staff member. So here comes Phil Long.
Okay.
Question.
Okay. On item 1, this is a bill that hasn't gone anywhere. Still in the policy committee in the House of Origin. And our position says none currently. And then I made myself I should excise some quotes out of this report. And it said, quote, "There are several concerns regarding earmarking provisions of the bill." And then I left out some, and then I said, "Staff has flagged these issues with the author's office and the sponsor." I guess my question here is, being we have no position, whose concerns are we expressing? The commission's?
Philip Ong, Legislative Director. Thank you for the question, Commissioner Hatch. During our regular communications with the legislature, we provide technical assistance as to what we believe would be issues that staff would flag for the commission for a potential vote.
But it's expressing it's expressing an opinion. And, as someone who lobbied for a long time, I didn't lobby on any issue that I didn't have a position approved for my client. And I do know that often government entities get a little sloppy with this. They say, we have no position, but, they start rattling off this stuff that makes people run for the woods. And so I sort of connected the dots. Here's a bill that's still in this policy committee of the first house. And we didn't oppose it, but we expressed concerns. And I would say concerns of who? Do you have a standing policy that said we have expressed concerns about these particular issues, or are we just flying by the seat of our pants?
Can I jump in, Commissioner Hatch, and just say that, as you might know, this bill, or a version of this bill, it's now in its 7th year. And the last version, which is similar to this version, the commission took a formal opposition position on. And I think it's fair to say that Phil has followed along on that formal opposition and the concerns raised based on that vote. But then again, I think the staff—
Was this some years ago? Is that
last year?
It was
last year?
Last session.
Yeah. On another bill, similar, I take it.
Same sponsor, same author, essentially the same public policy with slight differences, yes.
Mm-hmm. Yeah, well, I picked this one as an example, but I know in past commission meetings, I noticed similar patterns, and I'm just sort of putting you on notice that we should have the commission behind this. We shouldn't be throwing these things out, and when they're not backed by us. And I'm new here, so
just so I can
I want to know that when we're over there saying things about people's bills, that it's the opinion of this commission.
So Commissioner Hatch, just so I can get, I understand your concerns as far as if Phil were to make a representation that the commission has taken a formal position, but to the extent he's relying on the legal division analysis of the bill, and having talked to Phil a lot about these, often the comments that are expressed to the staff over there is, you guys say this is your goal here. That would not reach that goal. We have concerns that you're not getting.
Well, there's a difference between helpful assistance, that what you said here doesn't do what you tell me you want it to do, and there may be a better way to do it, and I think I've got an idea how you can do that. But it's another to say, well, we have concerns because this policy is one that we don't think is good. And that's what I read in this one. And so I didn't know about the previous position on another bill last year, but hey, you know what? Most of us are new here. We weren't here to vote on that policy. And so, maybe this would have been something you would take back to us and say, we want to take another oppose unless amended or whatever.
And I would say that I'm confident Phil would bring it to our attention if this bill were moving and we needed to, if he thought we should be taking a position, or if any of the commissioners think we should take a position on a bill, we could discuss it because it's all been noticed as part of the report.
Yeah, but I get that this wasn't just recent information that was passed on. This is done at the time. So you know what? You can nitpick it, but I'm watching this. I think it's important that these, concerns expressed are actually the concerns of the commission. If you don't have a standing oppose on a concept or provision, then you got to bring it back to us.
And Commissioner Hatch, I would add to what the chair has said, in that when I communicate with legislators or their staff, myself also being a former lobbyist, I understand the sensitivity of potentially sharing concerns that are not the position of a client. And so in any communication I have with legislators or staff, I tell them that this is a staff concern and not the position of the commission, and they should take the what was shared with them as technical advice, and do what they will with it.
I would only just, because this is part of the published agenda, right? It does say FPPC Commission. So I can see where it could be interpreted as it being an opinion or a position of the commission, not of the staff.
Okay. On that bill, I would note, Commissioner Hatch, you did note that it's not moving,
Yes.
that it's still in first house policy. Since this notice has gone out 10 days ago, there was a gut and amend of a bill that was already in second house with essentially the same language. So it's now moving in another vehicle.
Right, because it was heard in this policy house, this policy committee in this house already. So it'd be eligible under the rules.
It wasn't. It has not yet been heard in any policy. AB 14 has not been heard in any policy committee yet. The second bill had. As AB 249, which is the new bill, which because of timing wasn't noticed, had been heard as an environmental bill, and got to the Senate, and then it has since been gotten amended to be a political reform act bill. And
under the rules, if the bill had been heard but not voted on, it would still be eligible in a gut and amend to be moved forward.
Correct.
Without prejudice.
Right.
So I don't know when these concerns were expressed. They may have been back at the beginning of the process where it would matter, or whether they're just recently expressed. But I'm just telling you that I've seen this over and over again for year after year after year, various agencies that play this game and local governments that play this game. And if you don't have a position, I'm going to be calling you out on it. So either bring it to us or don't say it. Technical assistance is one thing. If they say, if the author solicits advice on it, that's fair game. But to just go in and say, we don't have a position, but we have some concerns about this. It doesn't fit very good in our world of how we think this law should be administered.
Noted.
That's a problem.
Thank you, Commissioner.
Thank you.
Any other comments on the executive reports? Okay, they will be submitted. And just in closing, I was going to remind everyone of our move, but I feel that has been discussed exhaustively. But it is after 30 years of being in this building, and it has been an enormous task. And I thank all of staff for doing the extra work to get us up to speed, to get ready to move, clean out house. And so that move will take place in July. Again, we don't know where this July meeting is going to be, but the August meeting will be in the new facilities at 1102 Q Street. So with that, unless there are any other questions or comments from the commissioners, I'd move to adjourn.
Second.
Commissioner Adaro?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
Yes,
This motion passes.
thank you.